to the top of the hour. Now, this particular moment in time, we get into the SMB no comment. With no comment, we get more of the insightful opinions and views from your public speakers. Now, this particular time, we're going to be looking at data protection and security in the country. This has been a very key challenge to Ugandans. In the last 2 years, if you're to follow back on the report that was released by NITA Uganda and the Uganda police, is that most of the Ugandans did lose a lot of money to fraud, billions of shillings in particular, over 15 billion Ugandan shillings, if I'm to break down for you the figures of how much was lost due to online scam and online fraud. Now, I'll tell you what, this particular situation comes at a time when Uganda recently enacted the Data Protection and Privacy Act 2019 to supplement constitutional privacy protections under Article 27 of the Constitution of the Republic of Uganda. Now, there was training for prosecutors to know how to handle such cases of the misuse of information of people. Now, we're looking at the Data Protection and Privacy Act in Uganda. Baker Birukuja, who is the Manager, Licensing and Legal Affairs Data Protection, NITA Uganda, takes us through the SMB no comment. Good morning.
Just conducted a training, training prosecutors from the Office of the Directorate of Public Prosecutions about how to enforce this law. It's a relatively new law, came into force in 2019, and the regulations last year. But what is not new is the collection of this information, what we call personal data, such as your name, academic background, location, financial information, amongst others. These have always been collected for various purposes, provide you with a service if it's government, private institution to give you a service, or even you've given them your consent. So the office has been emphasizing the message of every person, be it public or private, that's collecting this information to register with us, but also, to put mechanisms in place to secure this information. So we've been engaging very many people. We started a campaign, your personal data is private, but there have been a number of complaints around misuse of this information. Now, the law requires that every person that misuses this information is prosecuted, and that is where the Office of the Directorate of Public Prosecution comes in, because they are in charge of prosecution. So today it was equip them, inform them, of course they already know these aspects, but letting them know as regulators where we come in. So that's what we've been doing today. And
okay, and that is in details of the SMB no comment. The prosecutors were actually having more of the trainings, and these trainings is to at least get to understand the idea about data protection, the Data Protection and Privacy Act. So this training was for prosecutors to know how to handle such cases of misuse of information for people. I do remember last week also the Right Honourable Speaker to Parliament, that is Right Honourable Anita Ann Among, did mention something to do with the misuse of information, more so with people who use social media. With social media, people tend to at least disseminate wrong information. Not even to at least, they disseminate wrong information. And also, she cautioned the journalists upon disseminating wrong information or giving out wrong information to the people. Now, apparently, when you look at this situation, among the offenses and the penalties for the Data Protection and Privacy Act is that Section 35, a person shall not unlawfully obtain, disclose or procure the disclosure to another person of personal data held or processed by a data collector, data controller, or data processor. So someone is supposed to receive information lawfully. So the information that you're supposed to render out, or information that you're supposed to receive, you're supposed to receive it lawfully by the law. You're not supposed to receive information minus at least getting it lawfully from the data collector, Now, the data collector, this comes in various cases. Now, there is also a data controller and a data processor. Now, information changes differently. I would give my example of back in school when we used to receive information. And our teachers would actually tease us more in a situation that they would give you information from the word go. Your 4 people, the information, or let's say a message received by the first person changes direction and dimension by the time it reaches the 4th person. It can be set in a reported manner and then someone misinterprets it. Now, information, the only challenge with information dissemination is that in most cases, how you perceive it changes. It can be delivered in the same way, but how you receive that information depends on you as an individual. Now, looking at the offenses and the penalties, under section 36, a person shall not unlawfully destroy, delete, mislead, conceal, or alter personal data. I'm breaking it down for you. Now, this is the Data Protection and Privacy Act. Now, then under section 37, a person shall not sell or offer for sale personal data of any persons. So this issue of selling personal data, you've seen people actually hacking into people's accounts and trying to at least sell them, or at least try to intimidate, blackmail, and all that. Now, the punishment for any person who commits any of the above mentioned offenses, which offenses? One, that of section 5, which says the person shall not unlawfully obtain or disclose or procure the disclosure to another person of personal data. Then 2, saying a person shall not unlawfully destroy or delete or alter personal data. Then 3 is that the person shall not sell or offer or sell personal data of any persons. Now, the punishment for any person who commits any of the above mentioned offenses upon conviction is a fine of up to 245 currency points. Now, that is the equivalent to 4.8 million Ugandan shillings, or imprisonment of not exceeding 10 years, or imprisonment of over 10 years, and an equivalent of 4.8 million Ugandan shillings. Let's have a look.
Organizations that misuse this information. Now, for those organizations, the law is two-pronged. They can be fined up to 2% of their gross annual turnover, and even every individual within the organization that misused it can
And now we are getting into more of the situation. This law will apparently come for people who misuse the social media information, and this is according now this is what Baker Birikuja has to say.
Social media can take many angles. There is misusing information, specifically what we're talking about today, the personal data. This could be people publishing other people's information, photos. We've seen pay slips without authorization or even consent. So social media being a platform mainly for publication and people to talk about themselves, now it has expanded to people using it to publish other people's information irregularly. And
now that is Baker Birikuja. Try to put in more of, I would say, it is Baker Birikuja from that is the Manager Licensing and Legal Affairs Data Protection at NITA, Uganda. So there's also questions of why do we need this law? I mean, sometimes we wonder and ask ourselves, why do we need a law of this nature? And why do we need this law? Is it is it for responsible use of information, or is it government trying to prove to us that they are working or anything? So Baker Birikuja also responds to this particular question. Why do we need this law?
we did, and why we need this law is that information is very key, be it as government or private. You know, government can't provide you with a service unless they know who you are. Then private sector also to be able to understand your needs. But now why we have the law is that much as people need this information, it should be used responsibly. And where it's used irresponsibly, it's where the prosecutors that we've been training today will come in and...
Okay, so the other question would be awareness. You know, in most cases, some people tend to draw imaginations and say, Munai,